स्पीकरनी जॉईन केला का स्वाती?
नाही, अजून गेस्ट जॉईन व्हायचे आहेत मॅडम.
बरोबर. मी शेवटी बोलेल स्वाती.
का मॅडम?
मी शेवटी बोलेल, गेस्ट बोल. शेवट करेल मी.
हो का? म्हटलं प्रास्ताविक.
नेहमी प्रास्ताविक करू का रे? चांगला नाही वाटत ना. तू इंट्रोडक्शन दे गेस्टचा आणि त्यांना बोलू दे, मग मी
बरं, ठीक आहे.
शेवटच्या टप्प्यावर बोलते.
सूर्यवंशी सर, माझा आवाज येतोय?
हो मॅम, तुमचा आवाज एकदम क्लिअर येतोय.
ओके.
पार्टिसिपेंटला तुम्ही जॉईन करायला सांगा, खूप कमी आहेत पार्टिसिपेंट. आणि दुसरी गोष्ट, लिंक जे दिले ते चॅट बॉक्स मध्ये सेव्ह करा.
मॅडम, सुरू करायचं?
करा ना सुरू. सर काय म्हणतात, सरांचं म्हणणं आहे की पार्टिसिपेंट्स कमी आहेत, त्यांना सांगा युट्यूब लिंक दिली आहे म्हणून.
ओके.
ओके, नो प्रॉब्लेम मॅम. युट्यूब लिंक आम्हाला फक्त
नमस्कार सर.
ओके ओके, चालेल चालेल, ठीक आहे.
नमस्कार. आज दिनांक 31 मे 2022 संताजी महाविद्यालयामध्ये आज इंटेलेक्चुअल प्रॉपर्टी राईट्स या विषयावर एकदिवसीय वेबिनार आपण आयोजित केलेला आहे. आजच्या या कार्यक्रमाला अध्यक्ष म्हणून संताजी महाविद्यालयाच्या प्राचार्य डॉक्टर प्रिया वंजारी मॅडम उपस्थित आहेत. तसेच महाविद्यालयातील सर्व प्राध्यापक वृंद या वेबिनारला उपस्थित आहेत. युट्यूबच्या माध्यमातून सुद्धा विद्यार्थी आणि इतर प्राध्यापक जुळलेले आहेत. या सर्वांचे मी शब्दसम्मानाने स्वागत करते. आजच्या या कार्यक्रमाला प्रमुख अतिथी म्हणून डॉक्टर भारत सूर्यवंशी सर आपल्याला लाभलेले आहेत. सरांचा परिचय खूप मोठा आहे. सर 18 वर्षापासून सेंट्रल गव्हर्नर ऑफिस, मिनिस्ट्री ऑफ कॉमर्स अँड इंडस्ट्री येथे कार्यरत आहेत. सरांचे अनेक रिसर्च पेपर इंटरनॅशनल आणि नॅशनल याच्या जर्नल्स मध्ये प्रसिद्ध झालेले आहेत. सरांचं कार्य हे फार मोठं आहे. मी डॉक्टर भारत सूर्यवंशी सर यांना विनंती करते आहे की त्यांनी आपल्या या आजच्या मार्गदर्शनपर व्याख्यानाला सुरुवात करावी. डॉक्टर भारत सूर्यवंशी सर.
थँक्यू मॅम. तुम्हाला पण मी वेलकम करतो. मराठी शुद्ध येत नाही. सो आय ऑल्सो वेलकम यू ऑल. सो आय ट्राय टू यूज बोथ द लँग्वेजेस टू मेक यू अंडरस्टँड. आय विल स्टार्ट विथ माय शेअरिंग द स्लाइड्स. माझे स्लाइड दिसत आहेत का?
येस सर, इट्स विजिबल.
Okay, slides are moving.
Yes, they are moving.
So first of all, introduce where I'm working. I work under the Office of Controller General of Patents, Designs, Trademark, and Geographical Indications. As you might have knowing, we are having different locations, different offices like Kolkata, New Delhi, Mumbai, and Chennai. We are having PIS, that is patent information system. Now it is called as Rajiv Gandhi National Institute of Intellectual Property Management at your place, Nagpur. We are having trademark offices in addition to 4. One is at Ahmedabad and geographic indication of it as Chennai. These are the pictorial view of our offices: Mumbai, Delhi, Chennai, and Kolkata. This is our training center. You might have seen here we are giving trainings to all the IP officers, professors, students, faculties, law practitioners, even scientists or company managers, even for the foreigners who want to know about the Indian Patent Act. This is our website. If you are not knowing anything about the IPR, please click on www.ipindia.go.in and you can get all details about the different intellectual property rights. This is an awareness program. I cannot go in detail. If you want to be perfect, if you want to know more about the IPR, please see our website as well as keep updates on social media account like Facebook and Twitter. We are conducting many new programs every week and month. So you can join and be perfect in the IPR. Let us see today's topic elected to me is an intellectual property. As you can see my slide, something blooming in the mind, it means I can say product of mind is called intellectual property. As we are the human, we are the intelligent animal in the animal kingdom. Therefore, we are having power of thinking. Therefore, if you are sitting in the classroom, if you are teaching, or if in the lab, we are thinking that something you have to do new. So something which you are doing new, that's an intellectual property. So intellectual property can be said that the property which arises from human intellect, or you can say product of human creation. So how it arises? For example, today I'm thinking that petrol diesel is available. I'm enjoying the facility. I'm moving here and there. What about the next generation? The fellow from chemical engineering, the fellow from biotechnology, microbiology, or physics or chemistry are thinking to give production of biodiesel. That's an intellectual property. Because I am thinking that's a product of human mind. That's an intellectual property. Another example, for example, in December 2019, we heard about the coronavirus. At that time, we are not knowing what is coronavirus, what is the treatment for that, and what is the vaccine for that. But scientists all over the world started to carry out the research in the field of biotechnology, and they came up with Covaxin, Covishield, and Sputnik also. What is this? It's an intellectual property on human thought. He has given solution for that. That's an intellectual property. So I can say something which arises from human intellect is called an intellectual property. That may be product, process, design, or more. Any kind of property that may be in the form of books, novels, or stories, poems. Something which arises from human intellect is new. That's an intellectual property. So let us see what is the background of intellectual property. Property means our mind directly goes to the way. Tangible form of property, we say, I'm having car, gold, flat, so I'm rich enough. But there is another kind of intellectual property that is called as intangible form of property, that is intellectual property, wherein we are having industrial property and corporate. Industrial property includes patents, designs, trademarks, and geographical indications. Let us see what is the definition of intellectual property. Intangible creations of whom? Human intellect. Again, whatever we are doing new creation, that is of the product of human intellect, having commercial value or asset like any other form of property. What are the any other form of property? Gold, flat, plot, or any other form. Same way, if you are having 2 or 3 flats at Nagpur, one you might have given on the rent, you are getting money out of that person, royalty. If you are selling that flat, again you are getting money. Same way, if you are developing new technology, for example, new car which run on hydrogen fuel, or the car which run on water, new technology, you are getting paid. Or a new paracetamol which can reduce your fever within 2 hours, again technology. From that also you can get the money. Therefore, it's an asset like any other form of property. There are different intellectual property. Patent or IP is called as an exclusive right. For example, you are getting patent on your name for any technology. Exclusively, you can sell it, you can license it, or you can manufacture it. Then no one else, nor your teacher, nor brother, sister can exercise the power of that. Therefore, it also called as a negative right. Because on whose name it is registered, that fellow can only exercise the power of that. Again, IP is an territorial right. If you are developing new technology, filing in India, it's valid only in the country of India. You cannot stop other fellow by using or making it. Therefore, you are supposed to file your application in other countries also. Again, IP is an licensable right. If you are getting patent for any technology, you can license to any other company. For example, today, if you are one of the fellows from biotech or pharma is listening my lecture, if you are developing vaccine for Omicron, you are developing, but you can license to Bharat Biotech of Hyderabad or Biocon of Bangalore also, and you can get money out of that. Therefore, IP is a licensable right. Let us see what is patent. Exclusive monopoly privilege are right granted by the government to the patentee for 20 years from the date of filing or priority for commercial gain in consideration of the full disclosure of his invention as a territorial right not owned. So once you are developing something new and disclosing in the government of India clearly, sufficiently, then government is giving you 20 years right. You can sell it, license it, and how much you want to earn, you can earn. For example, we got Covaxin, Covishield. Some we got government free, some are we got paid in private hospital because they are getting money out of that because they are developing the vaccine. Same way, any technology for developing can get money out of it. Let us see what is invention and discovery. Many people still unaware about what is invention or discovery. If you are writing some papers or doing some research, whether you are doing discovery or invention, that is you are not having idea. Simply you are doing. So discovery means finding or exploring something which is already is in nature. And discovery as such has no technical effect. For example, we know milk is having bacteria that is called lactic acid bacteria. Curd is also having bacteria that is lactic acid bacteria. By knowing that, the microbiology fellow or botany fellow or somebody is isolating that by using some process. So the process of isolation of the bacteria is new. Then you can go for the patent file, not for the microorganism as such, because in the literature survey, we know milk and milk product is having lactic acid bacteria. But by using genetic engineering technology, if you are modifying that microorganism, then again it is patentable because human intervention, not as it is. You are doing something practical. Therefore, always inventions are patentable in India. Now, what is invention? When we can say my work, my project, or my research, or my thesis is having invention. Invention means new product or process. Product means X-ray machine, herbal composition, a paracetamol is a product, a machine which can convert solar energy into electrical energy. Product. Process of production of beverage from something else. Process of production of medicine. Process of preparation of some new kind of recipe. So these are common process. So get a patent to say an invention, it should be product or process. Many people ask us, sir, idea is patentable? Idea patent hote ka? Ho. An idea kashi pahiye? The idea should be in the form of product or process, not idea as such. Therefore, it is patentable. Again, it should be new. Again, non-obvious, not public knowledge before the filing. It means even for the paper publication, what we check, if it is not in the public domain, then we go for the paper publication. Same way, if you are not finding our technology in the literature survey or in the public domain, then you can say it's an invention which is new, and you can go for the patent filing. Simple example of the invention, sharpener. Everyone is known to this from childhood to till today. But before 1822, there was no sharpener. C. A. Boucher is a scientist who developed this machine. And now we are seeing sharpener. But earlier he said tool. Tool means engineering. It's a big machine. Tool for sharpening a pencil, writing pen by saving of its own surface, because patent is a techno-legal document. So he has described the technology in the form of legal. Therefore, he has given the name to. Again, in the general knowledge, we have studied who has invented electric bulb, who has invented aeroplane, who has invented telephone. All those we know, but why they got awarded for the invention? Because first time they are did. So why can't you and me do the good invention? So I'll take the, I'm in lecture, I'll call you later. So electrical bulb, Thomas Alva Edison has got patent for that. Telephone, the Alexander Graham has got the patent. So I'll call you later. So मी नंतर बोलतो lecture मध्ये आहे. So can anyone tell me, by knowing this telephone in the market, in the public domain, why the scientists came up with the mobile? Please, virtually we are connected, so we can make this session as an interactive. Anyone can answer, students, professors, or any faculty can answer my questions. Why we have gone up to the mobile phone? This technology was already since 1876 in the public domain. Why we thought of that? Anyone, please? Anyone? Make the session as an interactive. Because this telephone is having two disadvantages. One, if I want to connect my near ones or dear ones, 10 times I have to dial. It's very tedious, hectic, time consuming. Again, I cannot just telephone from my cabin to my principal's cabin, because it is connected at a particular point where the connection is there. To overcome this, scientists of electronic and telecommunication carry out the research, and they came with the table phone, wherein directly I can dial. Again, I cannot change from my cabin to my principal's cabin. To overcome that, they came with the cordless phone, which are long. We can take in the hall, kitchen, and drawing room. But we cannot take in the meeting, nor in the jeep, nor in the car. Therefore, we came with the mobile phones in and around 2000. So, improvement in the technology we are doing. So don't think that to get a patent, something new you have to do. Even improvement in the technology is also patentable. Therefore, Nokia, Samsung all got patent. To overcome the problems, they are solving one by one. Same way in the medicine also. Earlier, if you take the paracetamol in the morning, it takes 6 to 8 hours to reduce your fever. But somebody come with new paracetamol formulation, which can reduce your fever within 3 hours. Good result. Again, improvement in the technology. So don't think something new you have to do. Improvement in the technology is also patentable subject matter. Bluetooth is an example of invention. See here, developed by Geoff Hudson has invented this. Before that, we are not having Bluetooth in our mobile, but now we are saying, I will transfer my notes, pictures, movies through the Bluetooth. It's an option. Technology. Nano car, vaccine. These are the examples of technology patents. Drone, smart card, the simple device is an example of technology. This fellow, Ranganathan, since 20 years, he used to work in the field of coconut and palm. He used to very tiresome while climbing the trees of very high trees. He never found any solution when he was an young, but in the middle of 50, he came up with a 4-lock pin system. If press on both the side of his that machine, directly can climb the tree. So it's an technology. Now everyone is demanding for that. Why can't you and me think of that? Most common mistakes by the inventors are they never go for the filing the patent. They go for the publications. Don't do like that. First file the patent, then go for the publication. By knowingly, unknowingly, if you are disclosing some conferences, then from the date of that disclosure, you can file the patent application within 1 year. Let us see another kind of intellectual property called designs. Design means shape, configuration, pattern, or ornament, or composition of lines or color combination thereof applied to any article in the form of 2D, 3D, or both. I'm having Bajaj iron box in my home, so the design is different. You might have having some other company iron box. You can check the design is different. I'm having in my office Bajaj fan. You might have having Crompton fan. Crompton डिजाइन इज डिफरेंट. सर मैं लेक्चर में हूँ तो मैं बाद में कॉल करता हूँ आपको, ठीक है? ओके. So the design different. I'm having LG fridge in my home. You might having Whirlpool fridge. The design is different. I'm having Timex watch. You might having some other kind of watch. The design is different. I'm having Samsung mobile. You can check with the Apple, Nokia, Apple. The design is different. I'm having Dell computer. You might have some other computer. The design is different. Even AC, Daikin is there. Samsung AC is also there. The design is different. You can check carefully. So each company is registering the designs. Plus designs. You might have different plus designs in your homes. Brush designs are all of these. Car designs, handle designs, Hyundai, Maruti Suzuki, Mahindra. You can check all the car designs are different. Jeep, Tata Motors, something is different. Mere functional or technical feature of the article are not considered in design. The term is 10 years. It can be extended for 5 years. Total 15 years. We can enjoy this. Then set of articles. Beautiful cup set. How it looks beautiful. Design. You can say sofa set. Nice. All the designs. Please mute them, dear coordinator. Mute them. Don't make any sound. I'll show the different designs. The samples of this design is different from this samples. This capsule design is different from this capsule. This syringe is different from this. So any kind of design, if it is not in the public domain, if you are developing new design, please go for the registration and take the benefit of that. Again, textile designs. These are the textile designs. Jewelry designs. So anything which is not in the public domain, you can go for the registration. I am having office bag of different design, but this is different difference. I have shown you this iron box. This iron box is different. My wallet is different from this wallet. This is something different. Mine is this kind of wallet. This wallet is different. This is a comb design. So this comb is something different from this design. So always something new, you can go for it. It's a round comb. This Aquafine, Aquaguard, Sunrise, rail water bottle, the design is different. You can check Fanta bottle design is different from Sprite bottle. So anything design, if it is not in the public domain, you can go for the registration. Simple designs are there. You can see configuration, surface pattern of the bottles are different. This brownish bottle is different from yellowish bottle. So all the designs are different. Again, some biscuits, we know Good Day, Parle-G, Monaco, Marigold, many more. But the design of this biscuit is different, which can attract to the small children with the Tom and Jerry face. The design is different. We know the pencils. Pencil, the facing of peacock and parrot is design is different. This is an example of technology. Garrett M. Morgan, while crossing the road, he saw a terrible accident between horse carriage and car. He not gone the same way. He was thinking, how can I prevent further accident? And he came up with the solution that is a profit. So if you think, you'll get the solution. You know, today we're having many shampoos like Dove, Sunslick, Vatica, many more shampoos are there. But you are Nagpur, this Gadchirli, this Gonde is full of flora and fauna. It's many medicinal plants. If somebody comes with herbal composition of dandruff, curing shampoo. New invention, because you are taking the medicine from your own area, crushing it and coming in the form of herbal shampoo. So something new. If you think, you will give the solution for that. That's an technology. Then simple design examples. Again, someone has got this design. So can anyone tell me why can't you and me think of doing sustainability? Because we are not thinking innovatively, something new. Therefore, we are not getting the idea. The students of National Institute of Design, Ahmedabad, carried out the survey in the people of construction companies who involved in the construction of houses. They are having many more neurological disorders, nerve damage, back pain, disc pain, because they are carrying stones, bricks, cement, sand on their head. Therefore, they are getting this neurological disorder. So he thought that, and he has developed design wherein it never touched to the head. now this design if you are using it had to come in the market. It comes, everyone can get it because it is having burden on shoulder, not much on the head, directly not touching the head. So you can prevent such type of neurological disorder. So new design you can go for the registration. Let us see another kind of intellectual property called trademark or brand name. Visual symbol, which may be word, name, brand, or numerical combination of colors to indicate the source of the goods. To distinguish from the goods of the others, or it gives the authenticity goods like Reliance, Airtel, Tata, Bata, are the example. It advertises goods and services. Protect the innocent public from buying the goods of secondary. For example, Pino Pond's powder, very common, male and female uses to apply on our face. The spelling is Ponds. Bottle is pink color with the different designs, small also, big also. But in secondary quality, they change the spelling like Pounds. We never check, we directly see the color. Ponds we read because we never check what exactly spelling we buy that. That's in secondary quality. Adidas shoes and chappals. Puma shoes and chappals. Some are in Mumbai side, if you go to Bendi Bazaar, we get in 200, which cost 4,000 in the mall because they are in the second rate quality. R with encircle is a registered trademark. TM means you have applied, you have to get the registration from the government of India. Duration is 10 years. It can be renewed every 10 years subject to the usage. There are different trademarks like trade names, collective mark, certification marks, taglines, slogan, shapes like Google, Adidas, Naukri.com, Edil Mange More, Bureau of Indian Standards, different marks are registered. Another kind of intellectual property called geographical indications. Place names used to identify source of origin, quality, reputation, or other characteristic products like dazzling tea, Kanchipuram silk sari, Kolhapuri chappal, Agra petha, Nagpur oranges. The term is 10 years. It can be renewed every 10 years subject to the usage. These are the different examples of GI like Makrana marbles of Rajasthan, Ratlami silk, dazzling tea, Kanchipuram silk sari, Katputli of Rajasthan, Bagh prints of Madhya Pradesh, Bengali Patachitra, Chirali paintings, Bidri Worli paintings. Magai pan, Devanelli pomelo, Apimidi mango, Kashmiri saffron, Sailicha Bia, Purvaranis. Another kind of intellectual property called copyright. Provides holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, and the term of protection is life of the author plus 60. You might have seen many singers know more, but still they are getting the royalty for their songs. Many authors know more, they are written the books, but still they are getting the royalty because of the life of the author plus 60 years. If you are writing books, novels, stories, poems, you can register under section 2 of the copyright. If you are doing artistic work under section 2 shall that. For writing drama, it's dramatic works can go under section 2H. Musical works under section 2P. Sound recordings under section 2XX. And cinematography films under section 2. You might have heard in the news, the name dialogue of this picture is copied and they are infringed the copyrights. The photo of first picture of that advertisement, same copied from Hollywood to Bollywood, Bollywood to Hollywood, South India to Marathi, Marathi to this, because even the how it looks, that picture also, drawings also, even the dialects also, sound recording also cannot copy. If they are copying, they are infringement of the right and they will sue them in the courts. I'll tell you one example how we can protect a single device with a different intellectual property rights. In the year 2004 or in and around that, 6, 7, 8, 10, the Sony TV, especially with the two hoopers on the top of this TV, very famous for clarity and sound also. Picture clarity was there. There, and it's a remote control mechanism. Sitting us so far away, we can operate the TV. That's a technology got the patent. How it looks beautiful with the color combination, they got the design protection. Sony name in this fashion, they got the trademark. The instruction which are there in the box of TV has got copyright. So single product, you can protect with the different intellectual property so that other competitor who involved in the manufacture of TV will never copy the technology, nor patent, nor design. For example, Samsung. It also manufactures TV, but never copy the technology. Sony, if they copy, Sony will sue them in the court. Therefore, you should protect with different intellectual property so that other will not copy. This is an example for trade secrets. What is trade secret? Trade secret is another kind of intellectual property wherein maintained secretly, never been disclosed to others. Therefore, I've taken pizza as an example so that you will understand more easily, because even parents, if you are a parent, you are tested it with their children. But the children of college or students, you might have tasted during your pizza parties or birthday parties. The taste of Domino pizza is different from the taste of other hotels pizza you are getting in every hotels. Again, the taste of that hotel pizza and this Domino's pizza is different from the pizza what is prepared in your home by your mom, spouse, or by sister or brother. This is different. Three pizza tastes different. Why? Because Domino's is adding some trade secret which are not disclosed to us. They maintain secretly. They disclose the people who work in the kitchen of that by non-disclosure agreement so that they never will disclose to others. Therefore, we don't know the formula of Coca-Cola. We don't know the formula of Mazda. We don't know the formula of Sprite because they are maintaining secretly and they're in the market same way. That is secret. Even you can check the Nokia, Samsung, Apple, all the mobile designs different. Patent is also different. Again, the instruction of that company is also different. So each product you can protect with the different intellectual property rights. What can do with the IPR? What can do with the IPR? Because students, those who are listening my lecture, if you are a science graduate, you can become a patent agent. If you are a if you are a science graduate, means if you are a BSc, BPharm, MPharm, or any science graduate, every year our office calls for the examination of the patent agent. So you can do that. If you qualify, you will get job. Again, if you are an arts graduate, commerce graduate, or law graduate, you can become a trademark agent or copyright agent. If you are having knowledge of IPR, you can work in the IPR policy of central government, state government, university, school, colleges. You can work anywhere else, or you can work in the NGO also. If you are having knowledge of IPR, you can work in the IPR firms. There are different types of Nagpur, Pune, Mumbai, Gurgaon, Delhi, big cities. You can join there. If you are in MS in chemistry, biotechnology, microbiology, physics, or any branch of B, you can join to the government of India, depend upon the advertisement and subject vacancy. There are again two papers, one is objective, another is descriptive. To qualify, you will get job in the government of India. You can also become an inventor because you are the faculty, you are having human intelligence, you can think and develop some technology. Always don't require education to do something new. You might have seen the Marathi movie, De Dakka, Makarantana's picture. He has developed one device which his brother-in-law sold in the Mumbai, and that company claims my device, but his friend has already registered that patent, and in turn he get crores of rupees at the end of the movie. That's a technology. That's an example of the patent. So you can also become an inventor. How? A simple approach. If you are doing project in the science or be young farm, you have to do the project. Identify some problems in and around you, solve that problem, definitely you can apply for them. For example, during Ganpati festival or Durga Puja festival, we bring many flowers, tulsis, leaves to the house. After a few days, we throw in the river, pond, or lake. What we are doing? We are polluting the aquatic life, and because of this disturbing the nature. What government does? They throw the chemicals in the pond, river, and they clean that, but it is affecting the aquatic plants and animal fishes in the water of the pond, river, or lake. If you are being a scientist, you should have given biological treatment of pond water or river water. That's a technology. That's an example of it. Or for example, production of biodiesel from my campus waste, or production of an beverages from grapes, or many plant products. Simple device. If you are a biotechnologist, if you are a pharma, then go for the preparation of herbal medicine for Parkinson's disease, or a cardiac extract for respiratory tract infections. If you are a biotechnologist, if you are a electronic engineer, a device which can make you alert that you are getting the heart attack. Simple device. A device which can give SMS alert to the farmer that animals are entering his field. Because already we got some signals. When water tank is filled on our top of house, then we get the alarm that water tank is filled. So why can't we make new invention that even if farmers can get an SMS alert that some animals are entering his field? Anything if you are developing new pressure cookers are there. How many company cooker are there? How they are invented? Where they thought on that problem, they are getting. Why different mobiles came? They're thinking and they are giving. So something, if you are solving the problem, you can apply for the patents. To get a patent, your technology, your subject matter, your project should be new. When we can say that your technology is new? When it should not be published in India or elsewhere. Or it should not be in the prior public knowledge or prior public use within India, then we can say. Or it should not be claimed before any specific in India or elsewhere. When we can say that you are fulfilling the requirement of invention. Feature of invention that involves technical advancement as compared to the existing knowledge, or having economic significance both. I'll give an example. How we can say technical advancement, as I told you, Alexander Graham Bell telephone to mobile phone. What is this? Technical advancement. Or having economic significance. Earlier mobile in around 2000, simple Nokia is of 5,000 rupees. Now 1,000, 2,000, up to 40,000. That's an economic significance. Or both. That's make invention not obvious to a person skilling the art. What is obvious? I'll tell one example again. For example, you are from Maharashtra, making a herbal tea. The process of making tea comprising steps of taking a cup of water, allowing it to boil, adding pinch of tea powder and sugar as per the taste. Again boiling, adding taste in it as an roots of some medicinal plants. Gauti chai or kavlacha mulya. We are adding in that to increase the taste of that. The fellow from Karnataka, if he is making the tea, he is also making the same process, but for the taste, he is adding ginger as a taste in it. The fellow from Gujarat is also having same step, but for the taste, he is adding cardamom, that's elaichi in the tea. The Andhra fellow who has visited Karnataka, Maharashtra, even Gujarat, and tasted the tea, he can use any one of the ingredient or all the ingredient to make the tea. So it's very obvious to make him, but in patent, but in technology, it should not be obvious to make the invention. Then it is fulfilling the requirement of invention. Again, while doing the result, you should get surprised instead. Or if you are giving solution to a long-standing problem, fulfilled of a long fulfillment, or a great technical progress if you are doing, definitely you can get patent for that. Again, it should be capable of being made or used in the industry. While filing the applications, essential events are, if you are writing the patent application, like your PhD thesis, EMPhil thesis, it should have title, object of the invention, prior art, drawback of the invention, summary, detailed description, examples, and claims. I cannot go in detail because it's an awareness. If you want to know in detail, you can join many programs which are going in our institutes. There are different claims. One is called independent and dependent claims. Independent claims, process of making herbal tea comprising steps of. That's an independent claim. Dependent claim, the process as claimant wherein taste ingredient ginger. Process as claimant wherein taste ingredient gauti char kavlaच्या मुळे. Wherein taste ingredient cardamom. So depend upon what you are doing, you can add that is called additional feature or multiple dependent claim. You can say for that. Now, how to file the patent application in India and who can file? Any person, individual, startup, anyone can file the patent application in India. How to file? You can go to the patent office, you can file, or by sitting in your own office online, you can file the patent fields. There are different jurisdictions. As you are from Nagpur, you are having the jurisdiction is Mumbai, so you can file that. Sir, I'm in lecture. Can I call you after 5 minutes? Okay. So, for example, Mumbai covers state of Gujarat, Maharashtra, Madhya Pradesh, Goa, and Union Territory of Daman Diu. So, Dadar Nagar Haveli. These are supposed to file in Mumbai only. What are the documents required? Covering letter, application form 1 to state what is the detail about the applicant. Proof of right to apply for that. In that form 1, column 9 has to be signed by that. Form 2 is required whether you are filing provisional or complete. Provisional means idea comes to your mind, soon you are filing. And complete means once you are completing all the lab work with the claims you are filing, that's called complete application. Form 3 is required whether you are filing in foreign countries, what is the status of that. Form 5 is to declare the inventorship. Form 18 is a request for examinations or drawings if any you have to give, if it is mechanical, electrical, and request for early publication or example you have to give. Again, these are optional. If you want to early publication, then only you can file the form 9. Form 2 is also optional. Pooja madam alit ka? Okay. Then again, fees for the filing of patent is 1,600 for natural person, 8,000 for the others, up to 30 pages of your application. If more than that, per page 160 for individual, 800 for the company, and 320 for the claims for the individual, 1,006 for the company. And if you are filing online, it's fee. If you are filing hard copy, 10% more than that. Again, for all the teaching institution, 80% fee concession. You are the teaching institute, so you are having 80% fee concession. You can file more than it. Form 18 fee is 4,000 for the individual, 20,000 for the company. If you want expired patent application to be granted speedily, then you can request under expired examination. You have to file Form 18E, and if you are choosing India as a PCT country like International Searching Authority or IP, you can, or applicant is a startup, or in your group one of the applicant is ladies, they can request. Fees is 8,000 for the individual, 60,000 for the companies. These are the various forms you can get on from the website. If you want to file online, you can file even online also. Just a minute, I'll take 1 minute break. Sir, we have to introduce Nagaratnam, madam. Her biodata is nothing. She is the registrar of plant protection variety. Like that, you have to introduce in 2 lines only. Time is 1:30. 1:30. Now next दीड वाजता आहे ना. माझं संपलं तर मी येऊनच जाईन. मला अजून 10 मिनिटं लागतील. Yes, okay. I'm having some lectures I have to introduce, so I spoken to my colleagues. So how we are giving the patents? Once you are filing the patent application in India, it's go for the digitization. We screen and classify depending on the subject matter, electronics, mechanical, biotechnology, microbiology, physics, medicine. We classify. During the classification, we use the international patent classification system, wherein we classify subject wise because we are having auto allotment system. For example, the cases belongs to an herbal composition. It has to go to the biotech fellow only, not for the engineering fellow. So classification must. If you are requesting for early publication, we publish within week or a month, otherwise 18-month publication. Once it's published, anyone can oppose that publication. That technology is already known, it is not new. Or many grounds A to F given in the section 21 of the Patent Act. You can oppose on any one of the grounds. If you are requesting for the examination, it's go for the allotment to the examiner and control. They carry out the search, they observe your application, they scrutinize the application, they put the objection, they make the list of the objects. That is called first examination report. Examiner forward to the controller, control again add, delete or modify the objection, forward to the applicant or applicant agent. Then you have to reply within 6 months. If you are unable to reply, you can take the extension for 3 months. Within 9 months, by hook or crook, you have to reply, otherwise it will be abandoned. If you reply, the reply is okay, then it will be granted, otherwise it will be rejected. Once it's granted, it will go for the post-grant publication. Therein, only interested person can oppose the application. For example, who is the interested person? Maruti Suzuki company is developing new engine, then Hyundai company or Tata Motors or Mahindra can oppose that application. That is called person interested. Once opposition comes, we institute the opposition board inside the office. They give the recommendation on the opposition board. The opponent's grounds are forwarded to the applicant. The applicant will give detailed reply. The reply which comes from the applicant again forwarded to the opponent. Again, he give reply for that. If applicant or opponent requests for the hearing, that's post-grant hearing, like across the table, like a court hearing, they come to us. We discuss each ground of the opponent with the applicant. If applicant able to overcome all the grounds of opponent, it will be granted. If he failed to overcome the objection of the opponent, it will be rejected. If you are granting or rejecting, we give the speaking orders so that they can appeal in the higher courts. What is the role of patent system? Encouragement of technology. Because from X-ray to we got city solution, AG belt to we got mobile phone. So all the improvement are there, providing reward as an exclusive right for your disclosure, making profit or earning royalty through putting the invention practice. If you are doing new technology, you can come in the market. Don't keep as a file record to get a promotion of principal, promotion of professor, like that. Come in the market. Transferring to public property after 20 years or once patent is ceased. What to do now? We came to know different intellectual property, how to file, how to protect. So please don't keep quiet. Save the benefit of patent system in school, colleges, universities, or any other campuses or in society also. Utilize the resource through organized R&D activities. Capture the global market judicially, earn the profit through the protected market only. Thank you. So please, you can discuss if you're having any questions with me. Please don't forget to feedback link. Madam, please share the feedback link in the chat box.
हो सर. धन्यवाद सर. सरांनी आपल्याला आजचा जो बौद्धिक संपदा अधिकार म्हणजे इंटेलेक्चुअल प्रॉपर्टी राईट्स वर जी खूप छान अशी माहिती दिलेली आहे त्याबद्दल मी सरांचे शतशः आभारी आहे. जेव्हा ऑफलाईन मध्ये परत एखाद्या वेळेस रेग्युलर क्लासेस वगैरे सुरू झाले तर सर आम्ही तुम्हाला नक्कीच आमंत्रित करणार आहोत. महाविद्यालयाच्या प्राचार्या यांच्या वतीने महाविद्यालयाचे उपप्राचार्य डॉक्टर श्रीकांत पाजनकर सर मी यांना विनंती करते आहे की त्यांनी आपल्या मार्गदर्शनाला सुरुवात करावी. डॉक्टर श्रीकांत पाजनकर सर.
धन्यवाद मॅडम. या ठिकाणी उपस्थित आजच्या या आभासी कार्यक्रमाचे अध्यक्ष आणि महाविद्यालय आदरणीय डॉक्टर सौ प्रिया वंजारे मॅडम, आजच्या या कार्यक्रमाचे प्रमुख वक्ते आदरणीय भारत सूर्यवंशी सर, कार्यक्रमाच्या संयोजिका डॉक्टर स्वाती वाकोडे मॅडम आणि झूमच्या माध्यमातून उपस्थित महाविद्यालयीन प्राध्यापक वृंद. या ठिकाणी नुकतेच सूर्यवंशी सरांचे अतिशय अभ्यासपूर्ण मार्गदर्शन पीपीटीच्या माध्यमातून झाले आहे. महाविद्यालयाचे हे वर्ष सुवर्ण महोत्सवी वर्ष म्हणून साजरे केले जात आहे. या वर्षामध्ये अनेक चांगले सामाजिक कार्यक्रम आम्ही महाविद्यालयात राबवले आणि आज देखील चांगल्या विषयावर वेबिनारचं आयोजन या ठिकाणी करण्यात आलेलं आहे. बौद्धिक संपदा अधिकार कायदा याचा जर आपल्याला अर्थ सांगायचा झाल्यास आपल्याला तो असा सांगता येईल की जेव्हा एखादी व्यक्ती किंवा एखादी संस्था आपल्या बुद्धीचा वापर करून एखादी निर्मिती करते, त्या निर्मितीवर मर्यादित काळापुरती तिला प्राप्त झालेली मक्तेदारी असते. साधारणपणे वेगवेगळ्या स्तरावर जर आपण विचार केला, कला, साहित्य, चित्र, शिल्प, संगीत, नाटक यावर कॉपीराइट म्हणजे ज्याला आपण स्वामित्व अधिकार असं म्हणतो, साधारणपणे एका उत्पादनाची ओळख चिन्ह असेल ज्याला आपण ट्रेडमार्क म्हणतो, किंवा ब्रँड नेम किंवा उत्पादनाची ओळख बनवलेले घोषवाक्य हा देखील एक ट्रेडमार्कचा प्रकार आहे. म्हणजे तुम्हाला उदाहरणादाखल सांगायचं झाल्यास आपल्याला असं सांगता येईल की एखाद्या व्यक्तीने शोध लावल्यानंतर ते लावण्यासाठी त्याला जे काही कष्ट झाला, पैसा, वेळ त्याने जो घालवला, त्याचा मोबदला म्हणून सरकार त्याला मक्तेदारी देते. या कालावधीत तिच्या मालकाशिवाय दुसऱ्या कोणत्याही व्यक्तीला ती वस्तू बनवण्याचा कोणताही नैतिक अधिकार नसतो. जर कोणी बनवण्याचा प्रयत्न केला तर त्याच्यावर कारवाई होऊ शकते. आणि म्हणूनच ती वस्तू बनवण्याचा अधिकार हा कोणालाही नसल्यामुळे कोणीही ती वस्तू बनवू शकत नाही. आणि त्यामुळे अर्थातच त्या वस्तूच्या निर्मिती करता बाजारामध्ये कुठल्याही प्रकारची स्पर्धा निर्माण होत नाही. जगभरात हा दिवस 26 एप्रिलला साजरा केला जातो. जागतिक बौद्धिक संपदा दिवस म्हणून हा साजरा केला जातो. आणि हा दिवस भारतात 2000 पासून साजरा केला जातो. एवढं बोलून माझे मी 2 शब्द संपवतो. धन्यवाद.
धन्यवाद सर. आता कार्यक्रमाचा शेवटचा टप्पा आहे आभार मानणे. मी याकरिता डॉक्टर सुधीर गोरघाटे सर यांना आमंत्रित करीत आहे. डॉक्टर सुधीर.
धन्यवाद मॅडम. आज या ठिकाणी नुकताच बौद्धिक संपदा अधिकार या विषयावर कार्यक्रम संपन्न झाला. महाविद्यालयाचे यंदाचे वर्ष हे सुवर्ण वर्ष आहे. याचे औचित्य साधून या ठिकाणी अनेक सामाजिक कार्यक्रम राबविण्यात येतात. आज सुद्धा महाविद्यालयामध्ये बौद्धिक संपदा अधिकार या विषयावर या ठिकाणी वेबिनारचे आयोजन आभासी पद्धतीने करण्यात आले. आजच्या या कार्यक्रमाला अध्यक्ष म्हणून लाभलेल्या महाविद्यालयाच्या आदरणीय प्राचार्या डॉक्टर प्रिया वंजारी मॅडम, त्यांनी आम्हाला अतिशय मोलाचे मार्गदर्शन केले. त्यांची प्रेरणा आम्हाला सदैवच मिळत असते. त्यांच्या प्रेरणेने आणि सहकार्याने महाविद्यालयातील प्रत्येक कार्यक्रम यशस्वी होतो. त्यांचे मी मनपूर्वक महाविद्यालयाच्या तर्फे व्यक्तिगत आणि महाविद्यालयाच्या तर्फे मनपूर्वक आभार व्यक्त करतो. त्याचप्रमाणे महाविद्यालयाचे उपप्राचार्य डॉक्टर श्रीकांत पाजनकर सर यांनी देखील मोलाचे मार्गदर्शन केले. त्यांचे देखील मी या ठिकाणी आभार व्यक्त करतो. आजच्या या कार्यक्रमाला प्रमुख वक्ते म्हणून लाभलेले आदरणीय भारत सूर्यवंशी सर यांनी या ठिकाणी पीपीटीच्या माध्यमातून अतिशय मोलाचे मार्गदर्शन केले. त्यांचे मी आभार मानतो. IPSA चे समन्वयक डॉक्टर निहाल शेख सर यांचे देखील मी या प्रसंगी आभार व्यक्त करतो. कार्यक्रमाच्या संयोजिका डॉक्टर स्वाती बापोडे मॅडम यांचे देखील मी आभार व्यक्त करतो. आजच्या या वेबिनारला आवर्जून उपस्थित राहिलेले सर्व प्राध्यापक वृंद यांचे देखील मी आभार व्यक्त करतो. आजचा कार्यक्रम यशस्वी होण्यासाठी प्रत्यक्ष आणि अप्रत्यक्ष ज्यांचे सहकार्य मिळाले त्यांचे मी आभार मानतो. पुन्हा सर्वांचे आभार मानून माननीय अध्यक्षाच्या अनुमतीने आजचा हा कार्यक्रम संपन्न झाला असे मी जाहीर करतो. धन्यवाद.